Hello, and welcome to Legal Talk, the legal talk show brought to you by the law firm of O'Donnell, Weiss & Mattei. I am your host, Jamie Ottaviano, and I'm a lawyer in the firm. O'Donnell, Weiss & Mattei has offices here in the borough of Pottstown at 41 East High Street, where we've been for over 50 years, and also in the borough of Phoenixville at 34-7 Bridge Street, where we've been for about 6 years. The firm practices in many areas of the law, from estate planning to estate administration, all through real estate, title work, including civil litigation and criminal defense. I'm here today with my colleague and co-host, Victoria Hollister. Victoria, welcome to the show.
Hi, Jamie. Thank you.
We're here today on the topic of the fundamentals of family law. And before we begin, I just want to make a note that we came across this topic based upon several questions, several cold calls that we get from the office with regard to family law. Also, I failed to mention the telephone number. If you have any questions with regard to today's program, or you have any questions with regard to any legal matter you may be experiencing, please feel free to give us a call at 610-323-2800. Also, please feel free to check us out on the web at www.owmlaw.com. We update that very frequently with great information for the entire community on legal matters, as well as you can submit any questions through the website. It gets to our business or our office administrator, and then it gets divvied out to the attorney that can handle it. And Vicki, that's a great segue on how we came to today's topic, because over the past several months to a year, we get a great deal of cold calls and questions through the website about family law.
Yes, we do.
And we figured that we would take this time and answer just in a very general way some of those questions. I know that you get a lot of questions because you practice solely on family law, whereas I practice in family law and some other matters. But Vicki, before we dive into some of those just general questions, for the general viewing audience, we're throwing around the term family law. What can you describe to the audience what family law means or what it encompasses?
Sure. Yeah, Jamie. Family law is that area of law that deals with family issues and domestic relations. It would involve marriage and then the dissolution of the marriage, which would be divorce or annulment, and then the ancillary issues that go along with divorce, such as alimony, counsel fees, and also other areas that often accompany divorce, such as child custody, support, which would be spousal support or child support, and would also include such things as protection from abuse, possibly adoption. So it covers a broad range of topics that involve the family.
Okay. And of course, one of the biggest questions that we get is concerning divorce.
Yes.
Whether it be a cold call or whether it be a website inquiry. Can you explain to our viewing community what generally is involved? Again, we're talking about the fundamentals of family law, so we don't want to get bogged down with anything too much, but generally speaking, what's involved with a divorce here in the state of Pennsylvania?
Okay, yeah, let me start by saying that, first of all, divorce can become very complex, and it can be very overwhelming for lots of people when they're going through it. And because of that, I would urge anyone who is considering divorce or whose partner has let them know that they are considering divorce, that they should consult with an experienced family law attorney to address their issues. Family law and divorce is very fact-specific, so the facts of each case are going to really help shape the way the case goes. But first of all, in Pennsylvania, divorce, of course, is the state dissolving the marriage between two people. And to file in Pennsylvania, one of the parties has to be living in the state for at least 6 months. So there is a 6-month residency requirement. Okay, once you have that residency requirement met, then you can file either in the county where the plaintiff lives, the person bringing the action, or where the defendant, the other party, lives. There are some other ways of doing it, but that basically is how a divorce action is started. It's started by filing a complaint.
And as we were discussing prior to the telecast, many people may not know that actually filing a formal complaint with the county court system is actually bringing a formal lawsuit or a legal action against the other party. So here in Pennsylvania, that's done, and of course it's done at the county court system, not at district court, but at the actual county court system. Reading and Berks, Westchester in Chester County, and Norristown in Montgomery County.
Right.
One of the biggest questions, if not the number one question that I get for family law, specifically for divorce that I get, is, well, how soon can we get divorced?
Right.
Is that often the case for you as well?
Yes. People often want to get divorced quickly. And the quickest way to get divorced is first of all, let me back up a minute and say that we do have fault divorce in Pennsylvania, but fault divorce is used very rarely. But beginning in 1981, we also got no fault divorce in Pennsylvania. And there are two types of no fault divorce. The first one is what we call a 90-day consent, and that is usually the quickest way to get divorced. So what happens there is one party files against the other, and once that other party is served, the 90 days begin to run. And those 90 days are considered a cooling off period to make sure that both parties have thought this through, that this is what they definitely want to do, to get divorced. But the trick is, if there's property involved, then the property has to be determined. Who's going to be responsible for the property, the debt, who's going to get the assets, how those things are going to be split up. So usually within those 90 days, those things are determined between the parties, and if they can agree to those things, then at the end of the 90-day period would be the earliest that you could ask the court to grant your divorce.
Now, in situations such as that, 90 days may be just too short of a time period. And as going back to what you said when we first opened up, it's a very case-by-case analysis. So obviously, if a husband and wife have a great deal of property, not only real estate but other assets, 90 days just may be too short of a time frame to get that taken care of. Correct me if I'm wrong, but I see more and more 90-day divorces, whereas the couple had been separated for many years or sometime beforehand and kind of divvied their stuff up prior to the filing for divorce, or the parties just didn't have a great deal. Maybe they were renters or sold the house, living somewhere else. It seems as though that the 90-day seems to play more towards those types of marriages. But correct me if I'm wrong.
No, I think that's true. The 90 days can be, long enough if there is not a lot to be
Certainly
divided up, if there aren't a lot of issues. Certainly, if the party has not acquired any real estate, there's no pension plans, there's really no assets to speak of. Maybe it's a young couple, a very short marriage, no children. In that case, there doesn't even need to be a property settlement. The parties can just get divorced. But more often than not, at least somebody has at least somewhat of a 401k plan through the employer. Maybe they just purchased a house a year or so ago. So there are issues that have to be resolved.
Okay.
And then, of course, too, if you have children involved, there are also the children's issues that need to be resolved. Now, those don't have to be resolved with the divorce itself. They can be resolved later, but those would be primarily child support and child custody.
Okay. Any other way, you had mentioned, I believe you said two no-fault grounds for divorce, or two methods that someone can get divorced, the 90-day. Is there also a 2-year separation divorce?
Yes, the other type of divorce is what we call a 2-year separation. And if one party wants the divorce and the other party does not, then there's really nothing the party wanting the divorce can do for 2 years. It used to be 3 years when we first had no fault, but then it was shortened to 2 years. So you basically have to wait out the 2 years, and then at the end of the 2 years, you sign your affidavit stating that the marriage is irretrievably broken, that you've been living separate and apart for 2 years, and you want the court to determine the disposition of the assets and debt. At that point, then the court will appoint a master, and then the master will start to take a look at the assets and debts and kind of work with the parties in working out their property agreement. It's possible that the parties have worked that part out and are just waiting for the 2 years. But normally, if it's a 2-year separation, we find more often than not that the parties really haven't worked out the property aspect, and then the court gets involved, and then it becomes an even longer process.
Now, I heard you use the term master with regard to the equitable distribution, and of course that's the distribution by the court of the marital assets. Can you describe to the viewing audience what the term master, who is that person? Is it a judge? Is it somebody else?
Okay, a master is, in areas of law where there's a high volume of cases, and family law being one of those areas where there's the most volume in many states, what we have done is appoint attorneys who are experienced in a particular area of law, in this case family law, and they are they're also trained. They receive special training in order to be a master, and then they essentially work for the county in which they work, and they are the ones who determine the outcome of the case. It doesn't go to a judge except on appeal. So the master is the one who determines the case. And each of the counties is different the way they handle the appointment of the master and then what the procedure is once the master is appointed. But in all cases, there will be a preliminary conference. Whether or not the parties attend, again, depends on the county. In Chester County, for example, the first conference is attended only by the attorneys, and then the attorneys would look at what information is still outstanding that they need to help determine what the marital estate is and so on. So it's a part of the discovery process gets finished up at that point. Okay. And then we go forward with more conferences and eventually a hearing to determine the way that the property is divided.
Okay, very nice. Ladies and gentlemen, we're coming to our first and only break, halftime if you will, so please stay tuned for some messages from our sponsors, and Vicki and I will be back as soon as that concludes. Thank you.
How would you build the perfect bank? Would you put it close to your home or your work? Would you make it a high-tech wonderland with web banking and 24-hour access? Or a hometown bank with tellers who know your name? If you could build your perfect bank, it might look a lot like National Penn Bank. Convenient branch and ATM locations, innovative technologies for 24-hour access, attentive personal service, and free checking with no minimum balance or monthly account fees. It's all right here at National Penn Bank.
There are many reasons people join AAA and renew their membership year after year. In addition to the peace of mind of emergency roadside service, AAA membership includes expert travel planning, exclusive discounts, and more. AAA members also get exclusive Show Your Card and Save discounts at participating retail merchants and can save money on theme park tickets, luggage, and travel accessories at the East Penn Travel Store. Join today and start taking advantage of all AAA East Penn has to offer. And visit us on the web at www.aaa.com.
Hello, welcome back to Legal Talk, the Legal Talk show brought to you by the law firm of O'Donnell, Weiss & Mattei. I'm Jamie Ottaviano, your host for the second half, and again here with Victoria Hollister, my colleague, and we're talking about the fundamentals of family law. And Vicki, just before we begin the second half, I just wanted to go back. We had mentioned about the 90-day divorce and also the 2-year divorce. That by far is the biggest and number one question that I get routinely. And I just wanted to go back because I think it's important. The and of course you stated this already, but I think it's just that
Sure.
important. The 90-day divorce begins the moment that the actual divorce complaint is served upon the other party. From that moment forward, then the 90 days elapses.
Right.
The 2-year separation begins from the moment the two parties are separated. That is, that there's no formal, or they may not be a formal divorce filed with the county, but the parties have been separated, and maybe the divorce comes afterwards. That's the biggest question that I get, and I just wanted to clarify that. But moving forward, and in the first half of the show, you had mentioned the no-fault grounds for divorce, and we got into that being the 90-day, the 2-year separation. I believe you also mentioned the fault ground divorce that we still have here in Pennsylvania. And can you just touch briefly upon what it means to be a fault grounds divorce, and what are some of the criteria or elements that the court looks at?
Okay, for fault divorces, I believe there's 5 or 6, I haven't exactly counted them, but they are willful desertion, if one party deserts the other, adultery, cruelty, which would involve abuse of one of the parties, bigamy, conviction of a crime that subsequently carries a 2-year incarceration, and then sort of the catch-all of indignities, which was what most people used, particularly just prior to no fault. It sort of just, in general, parties don't get along. So those are the grounds, but I think it's important to remember that there is no advantage to claiming fault grounds, because when the court looks at dividing property and debt, they're looking at the finances and the overall financial well-being of both parties. Fault does not play into it.
So regardless of whether someone was cheating on somebody or whether or not someone's behind bars, it really, court's just going to look at the economics of the case?
That's right.
Okay.
They will.
So, well then, with that being said, based upon your experience, would you say that it's rare for someone to want to go after a fault ground divorce as opposed to a no fault grounds divorce?
Yes, it is. I think sometimes people in the beginning think they want to go fault grounds because they're angry or upset.
Sure, and
But-
emotions are running high.
Right. It's a very emotional time, and but then when they realize it's going to cost them a lot more money, a lot more time, and there's really no end benefit to them, they realize that they're just going to get on with the financial end of the divorce. And one thing I wanted to mention, Jamie, when you were talking about the 2-year separation, and this is something that we're coming across more and more with having a down economy, is that people can't afford to separate sometimes. So what they do is they remain in the same house, and one party will still file the divorce, and your 2-year separation begins to run at the date the divorce is actually filed. So you don't have to be separate and apart for that separation to start in terms of, getting the divorce, the 2-year separation.
So in that instance, we're using the term separation, but yet a couple could be separated but still live under the house under Pennsylvania law?
Yes, you can.
Interesting.
Yeah, and there are a number of different factors that go into that, what the court looks at to determine whether or not parties are separated.
So Vicki, moving on, if I were someone in the viewing audience and unfortunately I'm thinking to myself, the marriage just isn't working out for whatever reason or no reason whatsoever, what would I want to have if I wanted to go out and contact an attorney? What information would you want for a client to have during, let's say, an initial office consultation concerning divorce and other matters?
Okay, well, as we've been talking about, divorce is primarily a financial matter. So the important thing to have is good financial records. And that's going to include tax returns for the last number of years, depending on how long the marriage is or how long any changes that have taken place financially, but generally 5 years of tax returns. You're going to want to have bank statements for the last few years. You're going to want to have any evidence of debt, such as your mortgage, credit card statements. You would want to have also statements of the retirement plans that both parties have. So basically all the financial information is what's important. Another thing that I encourage my clients to do is to take an inventory of everything in the house. Sometimes when people get near the point of divorcing, things start to be removed from the home. So I encourage people to take pictures of each room and then to make an inventory of everything in that room. And that includes things that can't be seen, such as things that might be in drawers and so on. If you have purchase prices for some of those items, that's important. Now, when people start dividing up their household goods, it's not something that is a major consideration in the division of assets, and that's because mostly furniture and personal goods are going to be given basically garage sale or Craigslist value. But it's important that one party doesn't have to go out and replace everything. So usually those items are divided up, the parties can agree to it, but it's good to have a starting point saying this is what we have and this is now how we can divide it.
Well, that leads us to what I believe to be the number 2 question overall that I get from people is, well, what happens to my 401k, or what happens to my inheritance that I had received? What happens to the property that I had before I ever met my spouse? And that really comes down to the definition of marital and non-marital property. So can you touch upon let's first start with marital property.
Okay, in Pennsylvania, marital property is defined as anything that is acquired by the parties during the course of the marriage. Okay, so what's important here is not how it's titled or who receives it, but when it's received. So timing is what's important. Was it acquired during the marriage? Now, there are a few exceptions to that. That would be gifts to one person or the other, except for interspousal gifts. Those would be marital. Inheritance would be something that's not marital. Now, you can transform non-marital property into marital property. Say you receive an inheritance, Jamie, and then you take that and put that in a joint bank account, and you and your wife begin spending that money or buying things for the home or buying things that are sort of marital in nature. That would be assumed most likely to have been gifted to the marriage in that case. So most people who do receive inheritances keep that in a separate account and away from other joint assets, and that way it retains its status as a non-marital asset.
So let's give a hypothetical to the viewing audience. Husband and wife get married, and everything is hunky-dory, and they go out and they buy that first house together. They purchase it after the marriage, so regardless of whether it's in husband's name or wife's name, or most likely it's probably going to be titled jointly, but that is marital property.
That is,
correct?
That's correct.
Okay.
Yep.
And that marital property then would be subject to what we were describing before, equitable distribution, the court basically saying, okay, who gets what, and the division of the assets.
Yeah, it's important to remember that Pennsylvania is an equitable state, and that equitable meaning fair, as opposed to a community property state where everything is divided 50-50. In an equitable state, we look at a fair way to divide assets between the parties. So if you do have one dependent spouse who may not have the earning capacity that the other spouse has, or which would mean wouldn't have the ability to acquire income and assets after the marriage the same way the other spouse would, that spouse, the more dependent spouse, would probably receive more than 50% of the assets. Now, it's not going to be a lot more. It's not going to be 80-20, but it might be 55-45. It might be 60-40.
Now, of course, if there's marital property, I'm assuming that there's non-marital property?
Right. Non-marital property would be anything that you owned prior to marriage, except for the increase in value on that property. That becomes marital. So Jamie, if you owned a home before you got married, and even though you kept that in your own name and maybe you used it as a rental property, it was an investment, if that property was worth $100,000 when you got married, but the time you separate it's worth $150,000, then $50,000 of that value is marital and can be divided between the parties.
Understood.
Likewise, anything after separation is also non-marital. So if you are separated for 2 years and during those 2 years you acquire property, that is your separate property.
Okay. I see here we don't have much time left, and of course we have a great deal of information. Isn't that always the case? Touching very quickly upon spousal support, which again is a component of family law. How does one go about filing for spousal support?
Okay, when the parties are separated, the dependent spouse, that is the spouse that earns less or has less income than the other, can file for spousal support in the domestic relations office of the county in which they live. Okay. And then there's a formula whereby they will determine the correct amount of support. Some of the viewers may have also heard of the term alimony pendente lite, which is similar to spousal support, and oftentimes after the divorce has been filed, the court looks at alimony pendente lite instead of spousal support. There's really very little difference between the two.
Okay. And of course we hear the term alimony. Can you describe to the court, or to the viewing audience, what's alimony?
Alimony is support, but it's after the divorce, as opposed to alimony pendente lite and spousal support, which are both prior to the divorce. And whether or not alimony would be awarded to one of the spouses is up to the court's discretion. It's not automatic. And there are a number of factors that the court's going to look at, length of the marriage, who contributed, maybe contributing as a homemaker, contributing to the education of the other party, raised the children, whatever. There's just a number of different factors. But the biggest factor is there enough to go around in the divorce settlement so that each party would be able to support themselves? Generally, if there's a dependent spouse, there's going to be some alimony for at least a few years. But that sort of evens things out and helps that dependent spouse become more self-supporting.
Okay, we're really up against the deadline, but I just want to state, for purposes of child support and child custody, those are the really only two things in a family law matter, a divorce matter, that go on and survive an actual divorce decree, correct?
That's right.
Okay.
They do.
Ladies and gentlemen, we have run out of time, and we got through just about everything that we wanted, but thank you for joining us again. On behalf of O'Donnell, Weiss & Mattei, Jamie Ottaviano here, and my colleague Victoria Hollister. Thank you very much, and please stay tuned for next month's program.